Chapter 11 involves crimes against personal property. I'm going to split this discussion with regards to crimes against personal property and crimes against real property. And my discussion here is going to veer very differently from the book. Certainly the information in the book is all there, but I'm going to expand on those definitions and examples, and I'm also going to add a few crimes that are not in that discussion that I think are important, that should be brought out. So before I jump in, we're going to see some crimes that constitute white-collar crimes. White-collar crimes are nonviolent crimes, and they're usually committed in the business world. Things like embezzlement, computer crimes, extortion. Even though you don't technically have to be in a business arena to commit those crimes, but most of the time that's where we find them. Versus street crimes. They're also referred to as blue-collar crimes, and these tend to be more violent, and these include those homicide, robbery, arson, rape. So I just want to kind of bring white-collar crimes into the discussion, even though we've primarily been talking about the street crimes, and will continue to do so. But white-collar crime, such as embezzlement, fraud, is a white-collar crime. It's actually more costly to society than blue-collar street crimes, such as robbery. And according to the FBI, the annual cost of street crimes to society is about $15 billion. White-collar crime, $1 trillion for white-collar crimes. Does that surprise you? I think the surprising point is there's so much attention that's directed towards street crimes and in the news and so forth that we don't really realize the magnitude and consequences of white-collar crime or other forms of elite deviance in the United States. More white-collar and elite criminals benefit from different kinds of enforcement practices, more institutionalized. There's regulatory policies. They also have lots of money for the best legal representation. That's not available to street crimes normally. So as a result, the white-collar criminals are extremely difficult to apprehend and prosecute, even when they do a tremendous amount of harm to our society. And contrary to what many people believe that the white-collar crime is a victimless crime. It's not. Think about it. A single scam, a single computer scam, computer fraud, we'll talk about those things. A single scam can destroy a company, can devastate families by wiping out their life savings. It can cost investors billions of dollars. And we saw all three of those things in the notorious case involving Enron. I'll let you Google Enron if you're not familiar with Enron. I don't want to go off. We got a lot of stuff to talk about here, but you might be more familiar with more current fraud schemes that include Bernie Madoff and his big Ponzi scheme. And these Ponzi schemes are by far more sophisticated than what they've been in the past. And Bernie Madoff affected so many people, including the New York State retirement system. I'll tell you the gist of his case is that he got people to invest in his investment company, retirement funds and bonds and so forth, and he would take money, but he wouldn't put it in anything. And he promised all sorts of big returns, which is not normal. He promised always getting returns, which is never the case in the real world. There's always some losses and there's ups and downs. We're in a down period right now. But people would pay in, and then he would take the money that people were paying in at the lower level and pay out the upper levels. So the money was just kind of coming in, and he was paying it out. Oh, look, I can, put your returns. Look, paying out your returns, but they weren't going into anything. They weren't being directed into any real funds, and he was obviously pocketing money. And then and this went on for years, and when it finally, 2008, I think, is when our economy really took a hit in 2008. And a lot of people came calling for their money and he couldn't pay it back. And he confessed to his son, who was working with him, who knew nothing about this, what was going on, and then his son turned him in to the FBI. They made a movie about it. Robert De Niro played him. If you want to know more about the Bernie Madoff Ponzi scheme, I invite you to do a Google search. So these crimes of these privileged individuals within the context of, government, whether they're government office or their corporation, the reality is they can go undetected for a very long time, or not at all, and then not be prosecuted. And it usually stems from their relative power, status, or influence that they have. The cruise lines, those big corporations are constantly violating environmental laws, and they have big money lawyers to fight against the government attorneys. So nonetheless, they often get shielded from prosecution, and it's unfortunate. So we'll talk about some of the white collar crimes, and we are going to jump in. We're talking about personal property crimes, and we're going to start with larceny. Larceny involves the unlawful taking and carrying away of someone else's property with the intent to permanently deprive the owner of possession. Stealing, right? Let's use simple term, stealing. But before I go into this a little bit further, what's the difference between personal property and real property? Our personal property are things. Money, jewelry, cars, electronics. They can also be, those are tangible things. They can also be intangible things like copyrights and stocks and trademarks. The best way to think about personal property is it's anything that's not real property. And real property involves your land and the attachments there on it, like a house or a garage or a shed, permanent attachment on it. And that's real property. Everything else is personal property. Your dog or your cat, personal property. So larceny, stealing or theft, shoplifting is a petty theft, low level, up to, stealing an enormous amount of money from somebody, or stealing a vehicle from somebody, or taking somebody's credit cards. These can elevate the charges in New York State, depending on what is being stolen. In New York, it is a shoplifting or a petty larceny if you steal, and it's a misdemeanor offense, if you steal something or money that is worth less than $1,000, so $999.99. As soon as it's 1,000, it's the first level of a felony. Also, with what you take, if you take a vehicle in New York State, it doesn't matter if that vehicle is worth $500. It's considered a grand larceny because it's a automobile. So let's talk about what we need for our elements. We need our criminal act. And what is it? There's two. You have to take property of another, and you have to deprive the owner of their possession. There's two acts here. You take it, and you deprive the other person. And our criminal intent is that you know that you're taking it, and you intend to deprive that person of it. So there's two levels of intent here on each one of those acts. You have to know that you're taking somebody else's property, and you have to have the intent to keep it or deprive that person of it. So you and your friend walk into a convenience store to purchase some items. Your friend puts a package of gum in his or her pocket and leaves the store. Is that a larceny? Did somebody knowingly take something? Yes, your friend. Did they intend to deprive the owner? Well, if you're leaving the store and you're walking out, chances are that we can show that by inference that your friend intends to keep it and deprive the owner of it. So we do have a larceny here. You ask your parents if you can use the car. They say no. Later that day or night, you sneak out of the house and you take it anyway. Unbeknownst to your parents that you have it, they report it stolen. The cops find the car and you with it, and you are arrested for larceny. If you remember just a moment ago, I told you in New York that if you steal a vehicle, that is grand larceny. That is a felony charge, low-level felony charge. So the question is, was there a taking? Yeah, and you knew it. You know that you were taking somebody else's property. You also know you didn't have permission to do that. The question is, did you intend to deprive them of possession thereof? And what would be your argument? Right? It's your intent to return the vehicle back home when you're done using it, right? You don't intend to deprive them. That's where our question would turn. Unless your parents wanted to prosecute, but if your intent is I was just gonna bring it home in a couple hours, more than likely we don't have a larceny, but you might be charged with the unlawful use of a motor vehicle if your parents wish to press charges. So you see how that works? You were just borrowing the car. You intended to bring it back. But let's say you drove it because you knew someone who would pay you a couple $1,000s for it, and you go, you meet that person, you get the cash, they take the car, and they drive it off over the Canadian border, and it's gone. Grand larceny? Yes. Right? Because you intended to deprive the owners of rightful possession or thereof. All right. Any questions? Actually, there's one more point I want to raise here with larceny. What we've just went through was the larceny law in New York, and that's pretty general. That's pretty common as to what the law is. There are a couple minority issues that I'm going to bring up of jurisdiction issues in a minority of states. Some include the temporary, or they say temporarily or permanently depriving another. So it could be done on a temporary basis to deprive someone. So this is where Florida is getting into, you can't even like borrow somebody else's stuff without the asking sort of thing. So if we had that language in the law, technically you could be charged with some level of larceny because you did on a temporary basis deprive your parents of the use of the vehicle. But that's not the law here in New York, but you just have to be aware that there's that little component. Robbery. Let's talk about robbery. This is the most serious of theft crimes. It's a violent crime. In New York State, it is, if you are convicted of it, a person's convicted of it, it's mandatory prison. What is it? It is the forcefully, which could include intimidation or threat, of immediate harm and unlawfully taking personal property of any value of another's person or presence. So you use force or a threat of force or intimidation. You need that for this act to be considered a robbery. So it's kind of like theft, right? You're taking somebody else's property, but you're doing it now forcefully. So you actually have the person is present right there. What do you need for a criminal act? You need a taking of another person's property by force. Your act is not just taking, you're doing it forcefully. And our intent is, if you're doing those things, you have to do it intentionally. The purposefully, in some states, intentionally. In New York, we don't use the word purposely, we use intentionally, to commit the act. And in some jurisdictions, it requires the keeping of the property, even if that meant that you sold it to a pawn shop or on Craigslist. There's no requirement to keep it. But our criminal act is taking forcefully somebody else's property. Couple examples. I thought I had one on my slide. I do, but let me just go through a couple that aren't on my slides. Comparing this to the theft. If I put a gun in your face and want all of your money, give me all your money, and I'm putting a gun in your face. robbery. If you give me that, if I take it from you, right? If I don't take it from you, you give me a karate chop in the leg and I fall down and you run. Could it be attempted robbery? Sure. Absolutely. Gun in the face. I threaten to beat the crap out of you. I'm standing there with a bat. Give me all your money. What if it's a BB gun? If it's a BB gun and you think it's a real gun, that's robbery. That is robbery enough. Can I call you on the phone and say, give me all your money or I'll come over there and shoot you? No. Has to be done in your presence. Has to be done in physical presence. I'll share a story with you. True case. I represented she was over 60 years old, a woman who was charged with robbery. She was to put it in context, she was a very small woman. Maybe she was like 5'3", 5'4". If she was 100 pounds, I would be surprised. She was very small. Here at the local mall, she was running out of the Sears, which is no longer there. That's where Hobby Lobby is now. She ran out of Sears at the mall, out the door leading to the outside of the mall, not through the mall, carrying a flat screen TV. How she was doing that at her size, I don't know. And she was running and getting through those doors. And there just happened to be a big SUV parked at the curb, dropping people off. And she jumps into the back seat. There's two people in the front seat who happen to be college students. Jumps in the back seat with her big flat screen TV and she yells, "Drive, I got a gun." And so the kids freak out, of course, and start tearing on out of the mall parking lot. They don't get out of the mall parking lot. They're ultimately stopped by the mall cops, and then the state police come, and she's arrested for robbery, and come to find out, lo and behold, she doesn't have a gun. Does that matter? No. The question is, what would the objective person in the victim's position believed? And the driver thought she had a gun. What is she going to say? Show it to me? Why don't you show it to me first? No, right? Oh crap, here's this crazy lady with this screen TV who just jumped in the back of my SUV claiming she's got a gun, telling me to drive. They're driving. So that was an interesting case, and unfortunately she ended up going to prison. Let's try this example. An elderly woman is walking down the street. A young man comes running up behind her and grabs her purse. Robbery? Yeah, right? This is robbery. He's grabbing her purse from her. She may not see it coming, but this is a forceful taking of somebody else's property. Let's say she holds on to it. Oops, doesn't let go. Holding her purse strap in one hand, the young man takes it in his other hand, and then with his free hand shoves her at the same time, and then yanks the purse from her. She falls and lets go, and as he runs off, a good Samaritan tackles him and holds him while the cops come. He's arrested for robbery. Is it a robbery? She got her purse back. He didn't make it very far. We have a forceful taking with an intent to deprive her of her property. Yes, we have a robbery. This is way more than attempt. This is a follow through. This would be a full-fledged robbery. Let's talk about embezzlement. Slightly different kind of theft crime. Fraudulent is the taking of money or other property by a person to whom it has been entrusted. Some types of words you're going to see: take over, when you fraudulently take over someone's property, convert somebody's property, or seriously interfere with somebody's property. And this is different from larceny because there's no actual, you don't need an actual physical taking necessarily. You don't need, this is similar to, the office manager who is diverting the company funds into her own personal account. She's not actually taking the money in her hands, and she's actually in charge of the money, the person to whom it has been entrusted, and now is the one doing the taking. So if you've been entrusted with somebody's property and you do something with it after the fact, or attempt to do something with it after the fact, it's going to be considered embezzlement. So the criminal act is some sort of conversion. I don't want to use the word taking, because then it puts in your mind, oh, I actually have to touch it. You're just consuming or converting, taking over somebody else's property that they put into your trust, into your care, into your trust, or trusted you with it. This is a general intent crime. You have to know that you're converting the property. You don't have to do anything else after that, like intent to deprive them thereof. You don't need anything to follow. You just have to do the act of converting. Let's talk about a couple examples. While hauling a load of refrigerators from San Diego to New York, owned by National Appliance Company, Fred tries to sell some of the refrigerators. To display them, Fred breaks the seals, enters the cargo compartment, and opens 2 refrigerator cartons, and he sells them and pockets the $1,000. Is this embezzlement? Well, we got some property here, some property of another, refrigerators. They were entrusted into Fred's care. And what did he do once they were in his care? He sold them. And then he takes the $1,000. Embezzlement? Yes, this is a prime example of embezzlement. While hauling a load of refrigerators from San Diego to New York, owned by National Appliance Company, Fred tries to sell some of the refrigerators. To display them, he breaks open the seals, enters the cargo compartment, and opens 2 refrigerator cartons. But no one buys them. And they never leave, the refrigerators never leave the truck. Fred is arrested and charged with embezzlement. He argues there's no grounds for the charge because he never took anything off the truck. Is he right? So, what do we got here? We got somebody with control over somebody else's property. So we got that. And what do they have to do? Intend to convert the goods to his or her own use. And did he do that? Yeah, he intended to sell those refrigerators, but no one bought them. You don't need the follow through. His intent was to convert the goods to his own use. That is embezzlement. That's what makes this a general intent crime. You don't need the actual harm. You don't need the follow through. You just need the intent to do it. So here's the key point. I just said it. If a person has control over the property of another and has the intent of converting the goods, or the funds, could be money, to his or her own use, it is embezzlement. Another theft rule, law. This is obtaining property by deceit, false pretenses, where there is a representation of a material fact which defendant knows to be false, which he intends will and does cause the victim to pass title of his property. So basically, someone lies to get the other person to give him his property. So what do we need for these? We need the lie, and it has to be false, a material fact, something that convinces somebody to give them their property. So we need a lie, and it needs to be made knowingly. You intend to lie. You know you're lying. And you actually have to intend the consequences. This is a type of specific intent or result, consequence, whichever word you like, result, consequence crime, where the person actually has to give them the property. So if you lie about a material fact, if you don't get the person to give you the property, then you don't have a crime. Lying's not a crime. But if you convince somebody deceitfully to give them over your property, then we have a charge of false pretense. So George, I'll ask it. George persuades Stan to loan him his Maserati for a day. Okay, so Stan gives George his car. Stan thinks it's for a day, but then George keeps it and uses it for his own use. What crime do we have here? I hope you are saying embezzlement. Because what do we got here? We got Stan entrusting his Maserati to George only for a day. But then what does he do? He converts it for his own use. He keeps it. That's embezzlement. George persuades Stan to give him his Maserati so that George can allegedly, this is the lie, allegedly donate it to a charity. But he doesn't. He actually keeps it. So Stan gives George his Maserati on the material fact that George is going to donate it for charity. And that was the lie. This is false pretenses. See the difference between the two? We have a lot of different theft crimes going on. You need to keep them straight. Extortion. That's a big, scary crime word. It usually is attached with, like gangs and the mafia. Extortion also means blackmail, right? Blackmail, we usually hear that term a lot. Both the states and the feds recognize extortion as a crime. In New York State, it is the lowest level felony. It's a grand larceny in the 4th degree, a Class E felony. So it's the lowest level felony, despite its scary word. It's very extortion. And what it is it compels another to give his property by instilling a fear that if the property isn't delivered to the actor, the one who's trying to compel another, there's a whole laundry list of things. If they're doing one of these things to instill fear in another, then that alone is going to be the crime. You don't need the passing of the property. So let's look at these things here. So if somebody says they are going to physically injure their spouse if you don't give me $10,000, that right there is extortion. That. You don't need the person to give $10,000 for it to become extortion. Give me $10,000 or I'm going to tell your spouse that you're sleeping with somebody else. That's the expose a secret down at the bottom, down towards the middle. That's if there's some sort of instilling a fear of one of these things, that's extortion. You don't need the follow through. So the key here is our threat. I should say, the criminal act here is our threat. Our criminal intent is that it's done intentionally or purposefully. And because this is a specific intent crime, we got this fear. That's what you got to do. You have a cause and a harm. You have to cause fear. If somebody says to you, I am going to tell your spouse that you are sleeping with your secretary unless you give me $10,000, and you go, I don't care what you do. I mean, it's not, are you fearful? No, when you say, I don't care, I'm not giving you $10,000, and then they go tell your spouse. I mean, that's not extortion unless you are put in fear. You're instilling fear. And you have to intend to obtain property, the $10,000. You don't have to get it. You do not have to get the property. You just have to intend to get it. You don't give me $10,000, I'll post all those naked pictures of you on social media. So that's extortion. And our last theft crime is receiving stolen property. The idea around charging people who knowingly possess stolen property was to deter theft and to break up crime organizations and, kind of deter pawnbrokers who would get stolen goods and then sell them off. Nowadays, if pawnbrokers get stolen property, which they do still, and they do a lot of questioning when they receive the property in to make sure they're not receiving stolen goods. But if the police show up to a pawn shop, because that's where they've traced it, or sometimes, I mean, they go around town here when they're looking for stolen property here in Plattsburgh, the investigating office, law enforcement office will go and visit the pawn shops to see if anything had been turned in. And if there is, they have to turn it over. The pawn shop has to turn it over to the police. There's a lot of things that go up for sale on Craigslist that are stolen property. But the key here is knowingly possesses stolen property with intent to benefit yourself or another. And you're depriving the owner of its recovery. So our criminal act is receiving or possessing. You get them, you receive them, or you possess them, you knowingly possess them. And the criminal intent, and this is a general crime, is knowingly. You have to know that the goods are stolen. You also have to intend to benefit yourself or impede the owner of recovering the goods. That's why our pawn shops turn that stuff right over. Or if they learn that it's stolen, they report it. You might be asking, so how do you know that you possess stolen goods? Well, how would I know if I got the goods, if they were stolen or not? What do you think? You're going to have to ask yourself what are the circumstances. It's based on the circumstances of what a reasonable person would understand them to be. So this is back to our objective person. So this most common example, you're walking down the street and there's a van parked on the side of the road and someone slides open the door and you see a bunch of flat screen TVs in there and the person says, I'll sell you one for $20. What would a reasonable person believe? Right? The first thing you're going to say is, are those hot? Right? Meaning, are they stolen? Because who's selling flat screen TVs out of a van on a street corner for $20? Unless something's wrong with the TVs, right? Or they came from somewhere that you don't want to know, but you should know, right? So that, and like a prosecutor has to prove, the criminal intent, just based on those circumstances and what would a reasonable person infer, that those are stolen, and you knew or reasonably knew that they were stolen. All right. I mean, the obvious reason is that your friend shows up with a flat screen TV at your front door and he's like, hey, can you hide this for me? I just stole it from Best Buy and I need it to like hang out here in your basement. And you do. But that's possessing or receiving stolen goods. In New York, we recognize it as possessing or receiving stolen goods. So you just don't have to get them. So that is our theft of personal property crimes. All of these crimes we talked about involve the theft of somebody else's personal property. We're going to switch gears and we are going to talk about crimes involving real property. And then there's a tail end of that discussion where I just incorporate some other theft crimes and computer crimes and a couple important federal crimes that tie into thefts that we should discuss.